SwayamPrabha. Digital India. Educated India.
Welcome back to the course of Law of Torts, Consumer Protection and Motor Vehicles, to the 9th lecture. Now, in this lecture, we will continue on our discussion on negligence, which we started in the previous lecture. We have, in the previous lecture, started the discussion as to what are the elements. Now, I referred to a Supreme Court judgment where Supreme Court clearly said that negligence is a matter of fact. Whether there is a negligence or not is to be established to a matter of fact or factual circumstances. Now, in order to establish, there are three principal elements that are required to be factually demonstrated before the court to say that there was a negligence. What are these? One, that there has to be a duty of care. Second, that duty of care was breached. And third, that breach led to a loss or damage or injury to the plaintiff. Now, the first question is, where does this duty of care come from? Now, we said that when it refers to duty of care, we have compartmentalized and said, there is a duty of care by law in this certain extents. There is a duty of care by this by another set of law for this. But there was never an attempt to discover a common theory which connects that. Where does this duty of care in each of these situations comes, and where the thread breaks to say that this is not part of those transactions where the duty of care arises. And that job was taken in hand by Lord Atkin and other honourable judges of the Court of Appeals in the historic case of Donnell versus Stevenson. The facts of the case I discussed in my last lecture, I am not repeating. Now, in that case, the court explained two very important points to establish the duty of care comes from. One is the relationship proximity. The court said that the duty of care towards neighbor is because we are in proximity. So, if I do something which harms him, I should avoid, because that proximity gives me the idea that this is what I do, it will be a damage to him, so I can foresee. So, proximity and foreseeability. Now, Lord Atkin said that all the relationships which are falling within the category of proximity and foreseeability are where from the duty of care arising. And he gave example of the manufacturer's liability to show that in a case where a manufacturer is producing goods, he is not producing for his own pleasure, he is producing to sell, and who will buy, he knows, customers. So, therefore, it is his duty to ensure that goods which reach customer are reaching in a proper and due form. So, he has to take the necessary due care. So, that is where the duty of due care comes upon him. And on what things that he has to guard? All the foreseeable possible wrongs. So, when he manufactures a ginger beer bottle which is to be consumed, he has to ensure that it is safe, it is hygienic, it does not contain any elements which will convert it into a spurious or a dangerous item, food item. And when that happens, then there is a definite breach of duty of care. So, therefore, this duty of care for the manufacturer is arising from this proximity between him and the customer, and proximity here is not in literal sense, the proximity of relationship and the foreseeability factor. Now, up to this we discussed. In this lecture we will take forward the discussion on the other aspects relating to decision of duty of care. Then we will move to the next two components, breach of duty and damage. And then we will see some illustrations of how the new rule of negligence has been applied in different scenarios. And then the last topic will be res ispa loquitur, that means negligence speaks of its own. Now, this slide already you have seen in my previous lecture. It talks about the proximity and the foreseeability, the first two conditions to establish the duty of care, which evolved in the decision of Donner versus Stevenson. But there was a question that emerged in a very interesting case. Now, in this case, an investor of a company went through the annual audit report prepared by a chartered accountant firm of the company's balance sheets and the company's solvency. Based on that, who was a shareholder now planned to invest more. And after the investment was made, it was found that the company was not that solvent, or the company was actually not so creditworthy. And there was some kind of a non-diligent work on the part of the chartered accountant firm, which led to this publication of the report, which showed different. Now, this investing company sued the chartered accountant firm for failure to duty of care and consequential damage that it suffered. Now, the question was, the first, was there a duty of care? Now, where the court was little troubled was that there is no challenge in saying that with reference to the company's auditors, with reference to company shareholders, the auditor has definitely a duty of care, because the shareholders are investors. But the question is, does the chartered accountant firm, which is a company's auditor, has a duty of care towards all prospective investors and all prospective people who are at that point in time not the member of the company or a shareholder or an investor? And if yes, where it has come from? Then the next is this foreseeable? And in both this account, it was difficult to explain in this scenario that how a chartered accountant firm can be held, having a duty of care towards a prospective investor of a company. Then in that way, it would say that X is liable to every, say for example, IIT Kanpur, which is a responsible institution and esteemed institution of technology, science, has a duty of care towards the world at large. It is not possible. It has only duty of care towards its students. Now, if some other university does not teach science properly, IIT Kanpur cannot be held responsible for that. It has only responsibility towards its stakeholders, that is its students. So, chartered accountant firm has responsibility towards the shareholders, but not to any prospective investor of the market. And most importantly, where is the proximity? That was the court's first question. Where is the proximity? And there were some cases that happened in between Donner versus Stevenson to this particular dispute when it came before the court, wherein the law was used by the court, this proximity and forcibility, in a slightly complicated manner, which led to sometime indifferent decisions. Now, I am not discussing all those cases, you can read those cases, but definitely it is traceable that application of this rule in some of these cases led to some indifferent decisions which were self-controversial with each other. So, now in this case the court said that we are not only relying on this question of proximity and forcibility. We are going to add a third criteria to this proximity and forcibility which has been upheld by Donner versus Stevenson in determining the existence of duty of care. And what is the third criteria? The third criteria is just and reasonable that duty should exist. Whether it is just and reasonable? Whether it is just and reasonable to say that to all students of this country, IIT Kanpur has a responsibility to ensure good science and technology education continues. So, the third criteria that was added was just and reasonable criteria. So, now it is proximity, forcibility, and third is just and reasonable. The name of this case is Capero Industry versus Dickman. Now, what the court held, the proximity principle has already seen limits persons to whom a duty is owed. They are referred to the neighbours by Lord Atkin in Donner versus Stevenson and described to be those who are so close and directly affected by my act that I ought to reasonably have them in contemplation. That is when you say that people are in proximity or relationships are in proximity, who are so close and directly affected by my act that I ought to reasonably have them in contemplation. It has been further seen that proximity principle realistically refers to such a relation between parties as renders it just and reasonable that liability in negligence may be imposed. So, the court says that it is also seen in the way the decisions have worked in Atkin's own words in Donner versus Stevenson or in some other cases where it has been applied in such light, because there were some cases where there are controversy about the application of the rule, but in those cases where there was no controversy and it was said that it was applied in the real sense as Atkin had developed this rule in Donner versus Stevenson, the court in Capro Industry says that it refers to such relation between parties that it renders it just and reasonable that liability in negligence may be imposed. For example, between manufacturers, for example, between doctor and patient, for example, between lawyer and client, for example, between a railway company and its customer. So, it is just and reasonable that in those cases liability of negligence must be imposed. In other words, relationship must have been such that in justice and fairness the defendant, like a reasonable man, ought to have kept the plaintiff in contemplation while doing the act of which complaint is made. It is in this sense that the test of proximity may be briefly described as foreseeability of a reasonable man. So, through the reasonable man's angle in Capero, what the court brought in was a third criteria which is called just and reasonable. So, what the court devised the rule is after Donner versus Stevenson, which stands today also, is that we say that between these two set of parties duty of care exists because they are in such a proximity that it is easily foreseeable or contemplated that if A act something which is causing wrong or harm to other person by any reasonable being. So, by any reasonable being, or you can put it in this language, by any reasonable being or reasonable person, it is just reasonable to contemplate that the certain set of parties are in such a proximity relation that if an act is done which causes harm can be easily foreseeable. So, that just and reasonable angle was added. So, the proximity principle does not require physical proximity, the manufacturer has no physical proximity, and it was also said that proximity principle does not require physical proximity, which I have already said. So, therefore, after this case, the most important thing is that now the duty to ensure or to say that there exists a duty of care between these two set of parties, the following three elements are need to be established. One, that there is a proximity between them in their relationship that it is impossible that I will not be able to foresee that my act, if it causes harm to him, if I am any just and reasonable person. If I am just and reasonable person, it is impossible that I could not foresee the harm because we are in such a proximity relationship. So, this is where the duty of care will exist. Now, after establishing this through factual scenario, the next thing that you have to establish is that there is a breach of the duty. And here also the same test is applied, reasonable prudent man. So, no doubt there is a duty of care, but under what circumstances the reasonable prudent man would have committed a breach or thought that his act is a breach of the duty of care, act or omission. So, the question that is inquired is that has the defendant omitted to do something which a reasonable and a prudent man guided by those considerations which ordinarily regulate the conduct of human affairs would have done, or has he done something which is a reasonable prudent man have not done. So, A is a contractor of roads, road contractor, and he has been contracted to build a road, and where the construction site is, it is his duty of care that exists because of proximity to this fact that it is impossible for him to, as a reasonable person, not foresee that if he does not take this action or he takes certain action will cause the harm. For example, if he leaves a unguarded hole, trench, no barriers in the construction site, no caution, no sign or caution, no light. Now, among the four, in the first three cases, of course, he will be held liable, because this is a breach. Because if he has a trench dug and if he leaves it unguarded, it is any reasonable man will be able to foresee that any person walking on the road will fall and be injured. And this is a proximity, that any person who will come on that road, and if it is a road which is used by people for walking, which is normally done, how rarely maybe it is used, you cannot say that nobody will walk unless it is a road which is barren, completely prohibited for any person to walk. Even a barren or a lonely road may also have a sole stroller. So, on this presumption that this road is usually not used, if he keeps a trench unguarded and open, and if somebody unfortunately comes and falls, can he justify? Then usually this road is not taken up by, yes, if it is a pedestrian road and there is a motorcyclist, then he may say that I may not have, but then still also it will be difficult for him to justify. So, it is the proximity of the relationship of the road and construction and the user that it is naturally a just and reasonable person will foresee what possible consequences can happen if he leaves an unguarded trench. And if he after this also leaves an unguarded trench, then he has breach of duty. So, similarly, no barriers, breach of duty. No sign or caution, breach of duty. But no light, if light is impossible, but he has given enough sign and caution, he has put all barriers, then he may also be excused for no light. But if he does not take any of this, there is no excuse. No excuse. He is in breach. Because no reasonable man who omits to guard a trench, ordinarily cannot foresee what would happen because of his omission. Or similarly, where barriers are not required in a highway, if someone puts a barrier without giving any caution, so his act is itself negligent. It is a highway which is used by cars and motor vehicles who drive very fast. In the evening, he puts some barriers without giving any caution, because next day morning he will start working. So, he puts some barriers. So, that is the act. Now, if he has not given any caution, then it is clearly he can see in the proximity of those who are using the road, it is foreseeable that the barrier, putting the barrier will be danger to those people. No rocket science is required here. So, a degree of care which a man is required to use in particular situation is in order to avoid the imputation of negligence varies. However, the degree of care may vary. How much care and caution he should have taken, whether it is a light was necessary or a simple barrier was necessary, that is where the question comes of degree of care. In certain scenario, light was necessary and he has not done that, and he has put a simple thatch barrier, that will not work. So, the degree of care is a secondary question. The primary question is first whether he has taken that care. If he has not taken that care, then it is a breach. So, the illustration is with reference to degree of care. In a blackout condition, a new duty is imposed on persons walking on the road by reason of difficulty which the driver of the vehicle has of seeing a person or thing not illuminated by a light, and in those circumstances, the duty of such person to take all reasonable steps to minimize the difficulty of the drivers on ongoing vehicles. So, blackout is a very specific situation. Blackout means sudden power cut in the entire locality, complete pitch dark, or in war and emergency sometime people declare, the government used to declare blackout. Why? Because in the night the enemy aircrafts could not identify where are the civilian population, what are the defense areas. So, complete pitch dark. Now, in a pitch dark condition, your duty of care which you reasonably would have taken when lights were there in the highway is much more, because the drivers have to be also alert, but you have to understand the drivers have also limited condition. They cannot now put their headlights. They are driving also with a very small light, some of them may not be without a light. So, you have a double responsibility now to make sure that you minimize any risk which you would have not taken when it was a normal scenario. So, this is what is the degree of care. So, that is why I said light necessary or impulse barrier is a question of degree of care, that will be justified depending on the conditions, which is again factual, but the care which is necessary is something which is the first thing which has to be established. Now, there is a very interesting case which I would like to discuss, where these questions were discussed. It is a 2019 judgment of the Supreme Court, Director Kerala Tourism versus Deepti Singh. Now, in this case, Kerala Tourism managed a 5-star hotel facility. In KTDC in the city of Kumbakonam, very near to the sea, and it advertised it as a very premier property, and it advertised that it has all the excellent facilities such as wonderful restaurant, beautiful cuisine, very nice location, 24 hours X facility, 24 hours Y facility, okay, swimming pool, and people were attracted. So, this family went to stay in this hotel for their vacation, and the husband of Deepti Singh, who is the deceased widow of the deceased victim who filed this complaint, this case, the husband of Deepti Singh jumped into the swimming pool, and when after diving into the swimming pool, everyone could see that he stood up once and then again he fall down and then he was drowning. And seeing him drowning, everybody started raising alarm. There was a foreigner who was also a resident of the hotel, who was also in the pool at that point of time, came to his rescue and rescued him from the pool, took his body out with the help of other residents of the hotel or boarders of the hotel. In the meanwhile, the instructor or the lifeguard of the swimming pool also arrived to the scene, other hotel management staffs, but he had by that time already collapsed, lot of water had intake in his body and he was senseless. So, in that condition he was shifted to the hospital and within 2 days he succumbed and died. Now, after his death, his deceased wife filed a case of negligence and deficiency of service. This is a case under consumer protection. So, it came under from the consumer protection to the Supreme Court. So, the case was with deficiency of service, but again deficiency of service, the actual test is the test of negligence. So, deficiency of service under the Consumer Protection Act. And what was the deficiency of service? The deficiency of service was in 2 heads. The first was that the swimming pool was unguarded. The swimming pool was unguarded. That means there was no security, life saving security which is required present at that point of time, that in case if any person suffers any kind of problem, they were to be rescued. Second was that swimming pool was one of the major attraction that was advertised, and the facility was negligent. This was the contentions of the complainant. the contention of the petitioner defendant was that they were not negligent. They have taken all the necessary steps. Of course, they had manpower shortage. So, the person who was appointed as the lifeguard of the swimming pool was also given a simultaneous duty to be bartender of the bar which is just beside the swimming pool, and he was there, and when he immediately saw within minute when the foreigner was rescuing, he also jumped into the water, and he was actually the first. According to the hotel, he was the first to reach. According to Dipti Singh, the foreigner was first to reach. Other evidence was also discrepancies was there. But anyway, he attended. That was the contention. He attended immediately without any much late or delay. But unfortunately, he could not save. And secondly, it was also written on the pool that using swimming pool is at the risk of the customers. So, there was a statutory notice that was given that using swimming pool is at the risk of the customers. Now, the court examined this case on these questions, and court used the wind pools test determining whether there has been a breach of duty. So, we had seen the definition of wind field, which is the three elements which we have discussed. So, first the court says it is necessary to ascertain the quality of the reasonable person is a question of law. So, what is that reasonable person's vision here? That is a question of law. Okay. Secondly, it must be asked how much care and reasonable person given the qualities attributed to him would have taken in the circumstances. The factors that are permissible to take into account in this regard are prescribed by law, but the amount of care that is reasonable person would have taken given those factors is a question of fact. So, the reasonable person, asserting the qualities of the reasonable person, what should be the quality of a reasonable person to be applied in this case is a question of law, but how much care he should take, that is a question of fact. Thirdly, it must be determined whether the defendant took less care than the claimant's interest that the reasonable person would have taken. Now, the court, after stating this, and which is also a question of fact, stating this says that there is no special reasonable person scenario is required. Now, in technical cases you may require some technical person like medical negligence, etc. But in this case such is not necessary. It is a normal man of any prudent would be enough. Second thing, he said that applying that, now a 5-star hotel when it advertise that it has these facilities, it is presumed that it will have all these facilities part and parcel for open for the use of the customers, and it will take all necessary protection. Now, this statutory notice that using the pool at your own risk is meaningless. You are opening these facilities by virtue of these services at a premier price, attracting premier customers. So, premier customers will use these facilities. So, then you say that I am charging premier, but my service is not up to the premier mark. This is not a defense. No reasonable person will believe. And therefore, not having a full-time lifeguard or having a full-time lifeguard, giving him a part-time another associated service is a definite breach of care. And it is a breach of care by virtue of the established norms. So, therefore, by using this, the court clearly said that Kerala Tourism is negligent and therefore granted compensation. Now, in this line we see some more cases. The first case we see, the first line of areas where we see the cases are the manufacturers of duty of care. Now, as I said, the whole revolutionary approach to the law of negligence came because of this case Dono versus Stevenson. And this case was in connection to manufacturer's liability, that whether a manufacturer has any liability towards the end consumer. And the court held that every manufacturer of a product which is food, medicine or like sold by him to a distributor in circumstances which prevent the distributor or the ultimate purchaser or consumer from discovering by inspection any defect is under a legal duty to ultimate purchasers to take reasonable care that the article is free from defect likely to cause any injury or injury to health. So, there are some important points. Manufacturer of an article, food or medicine, sold by him to distributors or any others in a condition or in a manner which prevents the distributor or any other person or even the ultimate purchaser from discovering by inspection any defects. Then the manufacturer has a legal duty to the ultimate purchaser or the consumer to take reasonable care that the article is free from defect which cause injury. So, if we say a Coca-Cola can, now if there is inside the Coca-Cola can a dead insect body, can anyone till it is open and the content is poured find out? So, no intervener in between intervening agency or even the customer have no opportunity to find out in certain circumstances that what is inside except what is written outside. So, any person will believe it only contains Coca-Cola, but if you open and find there is a dead insect, then who is liable? Of course, the manufacturer Coca-Cola. And why is liable? Because he has a duty of care towards the ultimate consumer, which is due to this proximity that he is manufacturing to the consumer to be sold. Same with Kerala Tourism Company, he is advertising for people, inviting people to come to his premier facility. It is not MECD hotel, it is a premier facility. So, all the facilities that a premier facility will provide, he has to provide in the same quantity and in the same quality. So, therefore, he cannot say the swimming pool is to be used at the owner's risk. It is in his risk only the swimming pool has to be kept. Of course, he will maintain certain rules. If somebody does not follow those rules or norms, then some accident occurs, then it is of course not his responsibility. It is a case of what we will discuss in the next lecture, contributory negligence, the other party contributing. It is clearly written that you cannot drink and enter the pool and you consume lot of alcohol and then you dive yourself into the water and then you die. Now, you cannot hold the the company liable because you have contributed it, because it is clearly written no drinking, no using swimming pool after consumption of alcohol. But otherwise, in this case or in other cases, when such kind of things are not occurring, then you are 100% liable, because it is your duty to ensure that it is free of any impurity or any imperfection. And if it fails, then you are liable. The only condition which can save the manufacturer is, or in this case hotelite, if the article has reached the purchaser in a form which leaves opportunity for an intermediate inspection or intermediate examination. So, the only way the manufacturer can be saved if there is an intermediate examination. But this scope of intermediate examination has been also limited. In this case of Grant versus Australian Knitting Mill, where the product in question was innerwears, jackets, innerwears like banyans and those kind of products. Now, there it was claimed by the defendant that it left our office not in the condition, but when it was kept in the with the dealer or maybe in the shop, many people have used, somehow something has come. But the chemical test showed that residue of nitric acid, which is used for the washing. Now, because it was not properly washed, the residue of nitric acid was left. Now, that shows even if the damage or injury may be directly linked, but leaving that nitric acid residue is itself negligence. Now, whether damage was caused or not may be a question, or how much damage, or whether the injury that is claimed is directly linked. But the negligence, the breach, up to the breach there is no question. The moment it is discovered by chemical test that the residue, it is not an argument that it is an open substance. So, hence from people hand nitric acid residue cannot be left. So, no other condition. Similarly, in the case of Stannett versus Hancock, the question was supplying defective motor car, and the defendant supplied plaintiff a reconditioned motor car, and when it was found that the rear wheel was coming off due to the negligence on the part of the employees of the manufacturer, it was held that the defendant owed a duty of care to the plaintiff, and the car is intended for immediate use and should have been in safe condition, so they are liable for negligence. Now, there are two things. Now, when I started with the manufacturer's liability, I said it started with the case of Donner versus Stevenson, and Donner versus Stevenson actually restricted the use of this rule to only food and medicine, because that was a question in that case. But subsequently in Grant versus Australian Knitting Mill, this rule was extended to woolen garments, so the garments. Then in Stannett versus Hancock, it was to defective motor cars. So, now manufacturer liability applies to everybody, and now it has been extended through other legislations like Consumer Protection Act to even service providers. So, KRTDC is not a manufacturer, it is a service provider, it is providing hotel facility as hotel service. But the same rule has been extended, but it is not anymore rule of manufacturers, it is called the rule of duty of care. So, that is why I said this rule of duty of care has revolutionized the law of negligence. Now, similarly, this has been extended also to the cases of professional negligence. We have already discussed the facts of Caparo industry. Now, in Caparo industry, it was with reference to chartered accountants, which is a professional, and the question was whether they are liable or not. Now, of course, they were held not liable because the duty of care could not be, existence of a duty of care could not be established by the tests that were required, but it was not denied that if those tests could be positively asserting a duty of care, chartered accountants are outside the scope of negligence. Chartered accountants have been held as negligent in many cases. Now, moving to medical profession. Medical negligence is one of the most important areas in today's context. We are we were just 2 years back in a health emergency globally because of COVID pandemic, and thereafter medical services have become very expensive. Now, not everywhere quality medical services is provided and not everybody can afford for that, but negligence service cannot be provided. So, when a doctor is consulted by a patient, the doctor owes a duty of care in deciding whether to undertake the case, in deciding what treatment to be given, and also the method in which the treatment to be administered. So, the doctor's duty of care is in 3 steps. So, when a doctor will be held negligent, now no person in the world can guarantee that by this treatment a person will be recovered, or no person can say that the doctor, when he is treating or he is undertaking an operation, it will always be 100% successful. we talk about chances or probabilities. So, this treatment is successful because in 90 or 85% cases the treatment has given positive result. But there is a 10% case where it is not been successful. There are also surgeries where there is a 15, 20, even 30% chance that it will fail. Now, if such situation happens and in all those situations the doctor is held negligent, it would be absurd. So, therefore, where and what are the levels of negligence for the doctors? And the conditions are very clearly prescribed. The duty of care for the doctor are connecting to three things. One, deciding what treatment A. Sorry, A is deciding whether to take the case, that is A. B, deciding what treatment, and C, the method of the treatment, administration of the treatment. So, to decide whether to take the case, second, decide whether what treatment should be available, and ultimately the manner of administration of the treatment. Now, for example, the first question, I am a homeopath and somebody has come who has gallbladder. Now, I tell him that, see, if you wish immediate relief, the best way is to operate it. But operation can have certain side effects. The safer treatment is by homeopathic medication, but it will take time, your discomfort will continue for some more longer period and there is no immediate relief. Now, that patient says, no sir, I want immediate relief, I cannot take this anymore, I am in a very bad shape, you please give me immediate relief. Now, I will then have to refer it to a allopathic surgeon who conducts surgery. Now, at that point, if I conduct a surgery being a homeopath who does not have any knowledge, I am negligent, because I am doing something which I do not have first hand knowledge. Similarly, what treatment, I have to be very careful, and it is not that I have to prescribe the treatment based on what is the global, based on what is the lowest reasonable person of my profession should know. And lastly, how do I administer the treatment? Now, if there is a negligence in any of this, then I am held liable. In Achyut Rao Haribai Koda vs. State of Maharashtra, which is a 1996 judgment, Supreme Court said that a skilled medical practitioner differs from doctor to doctor. Very nature of the profession is such that there may be more than one course of treatment which may be advisable for treating a patient. Courts would indeed be slow in attributing negligence on part of doctor if he has performed his duties to the best of his ability with due care and caution. Medical opinion may differ with regard to the course of action to be taken by the doctor treating a patient, but as long as the doctor acts in a manner which is acceptable to the medical profession, the court finds that he has attended on the patient with due care, skill and diligence, and if the patient still does not survive or suffers a permanent ailment, it would be difficult to hold the doctor to be guilty of negligence. So, negligence in case of doctor is not decided on the basis that there are different course of action and he preferred one course of action over the other. Now, the example that I gave, the patient comes to a homeopath and the homeopath tells that you have two recourses, one surgery which will give you immediate relief, but there are side effects, another is homeopathy which will not give you immediate effect, but it will be treating you with a safe way. Now, it is on the patient. But as a homeopath, I know if the moment I say surgery and everyone wants immediate relief, the patient will not be there and I become a scrupulous person, immoral person. I do not suggest about surgery. I say, it will take 6 months, but I will treat you. And there is no other alternative. There I am negligent because I am lying. But if I do not know about surgery and I say medicine is available in both homeopathy and in allopathy. Allopathy may be little faster, but it has side effects. Homeopathy has no side effects, but it will be little slower. Then I am not negligent. I may not know about the surgery, and if the knowledge about the surgery is not so common, I am excused. And any treatment, there are several courses. So, you go to every doctor will suggest different ways. So, criminal negligence is also possible, similarly civil negligence. So, there is a degree of difference, and the difference I said recklessness. When the act is done in a reckless manner, and what is reckless? You know that what you are doing is going to be dangerous or fatal, and you know somebody will be injured, but still you do it. It is an example of recklessness. And criminal negligence is when it is reckless or in this manner. Civil negligence is where recklessness is not there. So, when a doctor knows very well that surgery is there, and still he says for his own profit continue my homeopathy and don't go to allopathy and give certain negative, it is a reckless act. And here the negligence is of criminal nature. Now, I come to the last topic, which is res ispa loquitur. This is a Latin maxim which says negligence speaks of its own. There are certain scenarios where you do not need to do anything. The act itself is proof that there is negligence. When an operation is conducted by a surgeon and he stitches the wound with a mop or a surgical instrument inside the body, and it is later discovered, then that need not require any further evidence, it is a proof, and that is called res ispa loquitur. So, in cases where the negligence speaks of its own, there is no need for further evidence establishing duty of care, this, that. Of course, some duty of care was there and which will be always there, but all these proofs are not necessary. So, an exception to the general rule of burden of proof. So, this is a rule of evidence actually. So, in a general rule of burden, alleged negligence is the first instance of the plaintiffs occur wherever the facts already exist in such a proper and natural interference. Immediately arising from them is the injury complained or caused by the defendant, where event charged as negligence tells its own story or the negligence speaks of its own. Then it is unambiguous and so clear, then there is no need for any further evidence. What are the elements of res ispa loquitur? The elements are: the event that caused injury to the plaintiff would not have occurred if someone has not acted negligently. Second, evidence presented rules out possibilities of fault on the part of plaintiff or a third party. And last, there is a duty of care of the defendant towards the plaintiff which he has breached. So, when these three elements are proved, then there is no further question. It is a clear case of res ispa loquitur. And in this case of Municipal Corporation versus Delhi, Shubhakanti 1966, where a clock tower which was to be maintained by the Municipal Corporation, due to lack of maintenance, complete lack of maintenance, fell down one day and injured 3 persons and 2 of them died. And Delhi Municipal Corporation was defending that it is an inevitable accident, it was not completely because of our fault, there was no structural defect, there was an inevitable accident or other reasons for which it is old. Court said nothing doing. The court said, applying the doctrine of res ispa loquitur as in the circumstances of the case, mere fact that there was a fall of a clock tower which was exclusively under the ownership and control of the appellant, that is the Municipal Corporation, would justify raising an inference of negligence so as to establish prima facie case against the appellant. And there is a special obligation on the owner of the adjoining premises for the safety and structures which he keeps beside the highway. So, it was beside the highway. So, if you are the owner of that, you have a special requirement. And if the structure falls into despair and creates potential danger, and sometime it happens, then in such case it is no defense for the owner to prove that he neither knew nor ought to have known about the danger. So, there is no need to prove. The negligence is apparently clear. So, I complete my lecture on negligence The next I will continue with the last component of negligence, which is contributory negligence, which is a defense. So, in my next lecture I will discuss contributory negligence to start with, and then I will discuss the law of nuisance. Okay? As far as negligence is concerned, the main theory of negligence I complete in this lecture. So, thank you very much being part of this lecture. I hope you are enjoying this course and looking forward to see you in my next lecture. Thank you very much.